Dear students, in the last module we studied about victimology and the science of victimology. After studying this module, you shall be able to know what is harassment, what are the types of harassment, harassment of victim during complaints, harassment of victim in the court, what is harassment prevention order, and what are the consequences of harassment. Let us start with the introduction to harassment. The acceptable definition of harassment is unwanted conduct on the grounds of race, gender, sexual orientation, etc., which has the aim or objective of either violating the claimant's dignity or making an intimidating, hostile, degrading, humiliating, or offensive environment for them. In very simple language, harassment is a word that describes any kind of ongoing torment. Example of harassment: in the office, workers required to be careful about sexual harassment. Harassment includes constant attacks or abuse and can be from abusing racial slurs to crank calling your ex-boyfriend every night at 3 a.m. Types of harassment. First is civil harassment. In general, civil nuisance is exploitation, extortions of abuse following sexual assault or grave aggravation by somebody you have not dated and do not have a close family connections with, like a neighbor, a roommate, or a friend that you have never dated. It is also civil harassment if the exploitation is from a family member that is not involved in the list of your domestic violence. So, for example, if the exploitation is from an uncle or aunt, a niece or nephew, or a cousin, it is considered civil harassment and not domestic violence. Second, criminal harassment. Unsolicited, annoying, alarming, or abusive conduct or words which are threatening and which are prohibited by law. Third, age. It is unlawful to harass a person because of his or her age. Harassment can include, for example, offensive remarks about a person's age, although the law doesn't prohibit simple teasing. Offhand comments or isolated incidents that aren't very serious. Harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. Fourth, disability. It is illegal to harass an applicant or employee because he has a disability, had a disability in the past, or is believed to have a physical or mental impairment that is not transitory, lasting or expected to last 6 months or less, and minor, even if he does not have such an impairment. The disability-based harassment must be sufficiently pervasive or severe to alter the employee's conditions of employment and create an abusive working environment. In determining whether a work environment is abusive, courts consider the frequency of the complaint, its severity, whether it is physically threatening or humiliating or a mere offensive utterance, and whether it unreasonably interferes with an employee's work performance. Fifth, gender. Gender-based harassment occurs when an employer, a supervisor, or an employee harasses another employee based on gender. If an employer fails to discipline his employees for gender-based harassment of their co-workers, he creates a hostile environment at workplace. Sixth, national origin harassment. National origin harassment involves treating people, applicants, or employees unfavorably because they are from a particular country or part of the world because of the ethnicity or ascent, or because they appear to be of a certain ethnic background, even if they are not. It also can involve treating people unfavorably because they are married to or associated with a person of a certain national origin, or because of their connection with an ethnic organization or group. It can occur when the victim and the person who inflicted the discrimination are not of the same national origin. Seventh, racial or color harassment. The harassment may comprise of words, deeds and actions that are precisely intended to make the target feel dishonored because of their race or background. It includes considering somebody a candidate or worker disapprovingly because he or she is of confident race or due to personal characteristics associated with race, such as hair quality, skin complexion, or various facial features. Complexion judgment includes considering someone negatively because of skin color, complexion. 8th, religious. Verbal, mental, or bodily harassment is used contrary to objectives since they pick to the training a particular religion. Religious harassment can comprise involuntary and unintentional transformations. It includes handling a person, an aspirant or worker, hostilely as of his or her religious beliefs. The law defends not only individuals who belong to traditional, prearranged religions such as Buddhism, Christianity, Hinduism, Islam, and Judaism, but also others who have honestly held religions. 9th, sexual. Harassment can happen anywhere, but is most common in the workplace and schools. It includes unsolicited and undesirable words, deeds, movements, gestures, symbols, or behaviors of a sexual nature that cause the target feels uncomfortable. Gender and sexual positioning harassment are part of these families. Involving children, gay or homo, is a common insult falling into this category. The main emphasis of assemblies in work in contradiction of sexual harassment is defense for women, but defense for men is approaching to well lit in current years. It is illegal to annoy a person, a candidate, or worker since that individual's sex. Harassment can comprise sexual harassment or undesirable sexual advances, desires for sexual favors, and further verbal or physical exploitations of a sexual nature. Harassment need not have to be of a sexual nature, however, and can include offensive remarks about a person's sex. For example, it is unlawful to harass a woman by saying aggressive comments about women in common. Both target and the harasser can be both a woman and a man, and the victim and the harasser can be the same sex. 10th, electronic. Electronic provocation is the unproven usage of electromagnetic waves to annoy a victim. Psychologists have known signal of auditory hallucinations, delusional disorders, or other psychological sicknesses in connection to societies supportive to those who claim to be targeted. 11th, online. Harassment leads to atrocities and offensive remarks at particular entities, converging such as on race, religion, nationality, sexual orientation. This frequently happens in chat places, through newspapers, and by transporting dislike email to intended gatherings. See cyberbullying, cyberstalking, hate crime, online predator, and stalking. Any remark that might be established, including or violent, is known to be harassment. While in the reaction to harassment is well thought out, a self-defense response by the person being bullied or harassed by those of another race or perceived difference from the individual that is pervasive and associated to the reason being harassed. 12th, police. Unfair conduct accompanied by law bureaucrats, including but not restricted to excessive force, profiling, threats, coercion, and racial, ethnic, religious, gender or sexual, age, or other forms of discrimination. 13. Workplace. Workplace harassment is defined as the aggressive, demeaning, or frightening actions directed at any person, employee, or a group of employees. The revolting dealing through merciless, malicious, hurtful, or humiliating attempts to undermine an individual worker or set of workers. Recently, issues of office harassment have got curiosity among specialists and investigators as it is transforming into one of the most sensitive areas of effective workplace management. In Oriental countries, it attracted lots of attention from researchers and governments since the 1980s. Because a significant source of work stress is associated with violent manners at workplace. Third domain countries are far late Oriental countries in that there are limited efforts to investigate the questions on workplace harassment. It is nearly unnoticed, and the administrative leaders, that is the directors, are almost unwilling or unconscious about it in the third world countries. Under occupational health and safety laws around the world, workplace harassment and workplace bullying are identified as being core psychosocial hazards. The police are supposed to make us feel safe and protected. However, several times we discover ourselves on the opposite end of the legal system and at the receiving end of police harassment. Harassment by the police is difficult to prove, but there are police harassment laws in position to guard you. Deficiency of simplicity about whatever is considered police harassment and the best legal course of action available to the harassed often result in legal questions that many of us does not have answers to. Law enforcement agents are hired to serve the public. It is their duty to enforce the law, but that does not give them the authority to act lawlessly. They essentially abide by the regulations outlined by the government and accord people certain rights. When officers act contrary to law and abuse their power, they are often guilty of police harassment. There are numerous actions that can qualify as police harassment. Police have the authority and the duty to question people suspected of committing crimes and victims too. They also have the authority and duty to lawfully look for evidence regarding crimes and to arrest those who they believe have committed crimes. There are certain kinds of questioning, examinations, and seizures, although they may be measured harassment. Interrogative may qualify as annoyance when it is arbitrary. 1/5, that is 22% of respondents who have interacted with the police reported harassment by police, with much higher rates reported by people of color. Almost half of the defendants, that is 46%, stated being uncomfortable looking for police support. Physical and sexual assault in jail or prison is a serious problem. 16% of defendants who had been to jail or prison described being physically assaulted and 15% reported being sexually assaulted. Understandably, many people feel reluctant to involve police in minor or even major street harassment offenses. There are various legitimate reasons why. They might panic that the police will not react or will not trust them. They might frighten the police will involve in victim accusing by interrogating their outfits or select to be out without help or late at night. Several individuals may sense that their societies are previously over-policed and panic that the management a harasser will face from police or the justice organization will be disproportionate to his or her offense. For example, entities and societies of color frequently face further severe results from legal procedures than their white matching part. Other individuals may panic more annoyance from police even when they are victims of a crime. 14th, law enforcement abuse. There are a number of ways that police and law enforcement can undermine the rights of a citizen. At times, such abuses are inadvertent, taken about by situations, faulty considerate of some refinement of law, or other types of good faith mistakes. In other cases, privileges are abused intentionally because of the prejudice, self-interest, vigilantism, impaired value judgment, conflicts of interest, or corruption. Such police misconduct can take several forms. Between them, arrest, harassment, police brutality, falsification of evidence, coercion, and in rare cases, torture and false imprisonment. 15th, abusive advocates. Lawyers, paralegals, and other professionals involved in legal advocacy can abuse the system in a number of ways. In some cases, illustration may properly described but nonetheless incompetent. In other ways, lawyers engage in misconduct in an effort to gain unfair advantage of their clients or in pursuit of some self-interest. 16th, abusive judiciary. Abuse from the bench can arise from various causes, including incompetence, conflicts of interest, bias or prejudice, judicial misconduct, and corruption. Court-related abuse and annoyance is the use of constant proceedings through judicial and quasi-judicial systems to continue to harass and abuse. These circumstances possibly will include through the court organization inappropriately by several court applications, on occasion to diverse authorities or misleading applications for short leave. As a line to that, several abusers will use the court procedure to abuse filing lengthy affidavits, mainly on long weekends or a day or two before court, to women who do not have lawyers or supports. In case of women, they use the process to humiliate and traumatize her. Advocates stated that they knew numerous women who would compromise everything to avoid court for those reasons. Often, the abuser will use a history of mental illness or substance use against her. They may even make unsubstantiated allegations or will use cultural values against her. Example, demolishing charges of adultery that didn't happen but will make feel shame to the family. Financially abusing. Some writers inscribe that court-related mistreatment and nuisance is a device to postpone child backing or other conversation. Some responding advocates and other employees recommend the court meeting out time is used to satisfy possessions or to create financial hardship. They also use this to drive up to the costs of a lawyer, setting up and then failing to join innovations or making numerous offers, occasionally 5 to 6 offers weekly over months. A harassment prevention order is a court directive to prevent you from harassment and exploitation by someone who has trained you. In order to get a harassment prevention order, you have to illustrate that the respondent has harassed you. An individual who is a target of aggravation, that is petitioner, may look forward for a preventive command from the court. The parent or guardian of a minor who is the aim of harassment may seek a restrictive order on behalf of the minor. The preventive order prohibits harassment and may be delivered in contradiction of an individual, which is a respondent, who has involved in harassment, or against organizations, it can be again a respondent, that have sponsored or promoted harassment. A confining order ends on the date specified in the order. This is usually 2 years from the date the order is signed. Anti-harassment directives are the important kinds of restraining directions that are accessible only to sufferers of aggravation. It is a civil instruction of the code expressing the person who harassed you not to trouble you again. 17th, anti-harassment order. Restrain the defendant from communicating and possessing you under scrutiny. Let the defendant to halt a specified distance away from your home, base or office. The act has been formed so that you will acquire directives for anti-harassment deprived of a lawyer by satisfying out the systems yourself. As you are looking for an instruction of the court without the assistance of a lawyer, you will have the administration and spade work to do. It is not rare for this to take several hours. Although the main significance of unknown legal system exploitation for victims is injustice, abuses of the legal system inflict harm in many other ways. Civil litigation and criminal defense of the innocent imposes mental anxiety, mostly dangerous, upon the gatherings involved. Often such stress will affect physical health as well. When the system is abused and justice is denied as a result, stress and its effects can be exaggerated enormously. The condition of legal abuse syndrome, that is LAS, as a method of post-traumatic stress disorder, that is PTSD, produced by moral destruction, legal abuse, betrayal, abuse of power, abuse of authority, lack of accountability, and fraud. Chronic and high-profile legal abuse have societal effects as well, together with disbelief of the law. Law administration and the legal system, rationalization of small offenses by generally honest citizens, and mental anxiety. The harassment is any manners that are undesirable, uninvited, or unsolicited, where the receiver regards it as offensive or undesirable. When an individual converses that the manners is unwanted, it is known to be illegal, even if the ways is not listed but indirect as much as it is unwanted, it is unlawful. There are many types of harassment such as age, racial, religious, national origin, disability, sexual harassment, etc. The police are invented to make us feel safe and protected. Yet, most of the time, we found ourselves on the opposite finish of the law and at the receiving end of police harassment. Harassment by the police and repeated visit to court frustrates the victim. Therefore, protection should be done from every form of harassment. Harassment inhibition command and laws are present. We'll conclude this module with the summary. First, the acceptable definition of harassment is unwanted conduct on the grounds of race, gender, sexual orientation, etc., which has the aim or objective of either violating the claimant's dignity or making an intimidating, hostile, degrading, humiliating, or offensive environment for them. Second, the exploitation is from a family member that is not involved in the list under domestic violence. Third, harassment need not to have to be of a sexual nature. However, it can include offensive remarks about a person's sex. Fourth, police have the authority and the duty to question people suspected of committing crimes and victim too. Fifth, the parent or guardian of a minor who is the aim of harassment may seek a restrictive order on behalf of the minor.